History of England, Chapter 12, Part 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to find out how you can volunteer, please visit LibriVox.org. History of England, from the Accession of James II, by Thomas Babington Macaulay, Chapter 12, Part 1. William had assumed, together with the title of King of England, the title of King of Ireland. For all our jurists then regarded Ireland as a mere colony, more important indeed than Massachusetts, Virginia, or Jamaica, but, like Massachusetts, Virginia, and Jamaica, dependent on the mother country, and bound to pay allegiance to the sovereign whom the mother country had called to the throne. In fact, however, the Revolution found Ireland emancipated from the dominion of the English colony. As early as the year 1686, James had determined to make that island a place of arms, which might overawe Great Britain, and a place of refuge where, if any disaster happened in Great Britain, the members of his church might find refuge. With this view he had exerted all his power for the purpose of inverting the relation between the conquerors and the aboriginal population. The execution of his design he had entrusted, in spite of the remonstrances of his English councillors, to the Lord Deputy Tyrconnell. In the autumn of 1686 the process was complete. The highest offices in the state, in the army, and in the courts of justice were, with scarcely an exception, filled by Papists. A pettifogger named Alexander Fitton, who had been detected in forgery, who had been fined for misconduct by the House of Lords at Westminster, who had been many years in prison, and who was equally deficient in legal knowledge and in the natural good sense and acuteness by which the want of legal knowledge has sometimes been supplied, was Lord Chancellor. His single merit was that he had apostatized from the Protestant religion, and this merit was thought sufficient to wash out even the stain of his Saxon entraction. He soon proved himself worthy of the confidence of his patrons. On the bench of justice he declared that there was not one heretic in 40,000 who was not a villain. He often, after hearing a cause in which the interests of his church were concerned, postponed his decision for the purpose, as he avowed, of consulting his spiritual director, a Spanish priest, well read, doubtless, in Escobar. Thomas Nugent, a Roman Catholic who had never distinguished himself at the bar except by his brogue and his blunders, was Chief Justice of the King's Bench. Stephen Rice, a Roman Catholic, whose abilities and learning were not disputed even by the enemies of his nation and religion, but whose known hostility to the Act of Settlement excited the most painful apprehensions in the minds of all who held property under that Act, was Chief Baron of the Exchequer. Richard Nagle, an acute and well-read lawyer, who had been educated in a Jesuit college, and whose prejudices were such as might have been expected from his education, was Attorney General. Keating, a highly respectable Protestant, was still Chief Justice of the Common Pleas, but 2 Roman Catholic judges sat with him. It ought to be added that one of those judges, Daly, was a man of sense, moderation, and integrity. The matters, however, which came before the Court of Common Pleas were not of great moment. Even the King's Bench was at this time almost deserted. The Court of Exchequer overflowed with business, for it was the only court at Dublin from which no writ of error lay to England, and consequently the only court in which the English could be oppressed and pillaged without hope of redress. Rice, it was said, had declared that they should have from him exactly what the law, construed with the utmost strictness, gave them, and nothing more. What, in his opinion, the law, strictly construed, gave them, they could easily infer from a saying which, before he became a judge, was often in his mouth. "I will drive," he used to say, "a coach and 6 through the Act of Settlement." He now carried his threat daily into execution. The cry of all Protestants was that it mattered not what evidence they produced before him, that, when their titles were to be set aside, the rankest forgeries, the most infamous witnesses, were sure to have his countenance. To his court his countrymen came in multitudes, with writs of ejectment
Sample complete. Ready to continue?